Welcome to our third lecture covering the topic of labor law. Let's begin where we left off. We're going to discuss the collective bargaining process. As I said in the second lecture, the union representation, the election is really a very, very interesting, exciting part of the topic of unionization. And the second most exciting topic is the topic of collective bargaining. So this should be an equally exciting presentation, so to speak. At least I hope it will. I hope I do justice to the topic. So let's get started. Let's talk about what collective bargaining is about. I introduced some of the concepts to you in our first lecture, so I'm not going to spend a tremendous amount of time with things that I've already covered. So once a union has been recognized, and this can happen either by the NLRB recognizing the union, in other words saying, yes, it is the exclusive representation for this group of workers, or if enough authorization cards have been shown, the employer can recognize the union on its own. But however it's come to pass and the union has been declared to be the exclusive representative for that group of workers, both parties have to engage in good faith negotiation. They have to negotiate or bargain in good faith. It is an unfair labor practice for either one to refuse to negotiate. Now, it's difficult to know, though, when a party is acting in bad faith. You can have a party who is going through the motions, who listens attentively, who asks questions, but you get the feeling they're not truly considering the proposals out there. And so it can be difficult to know whether the actual negotiation is truly in good faith. Now, neither side has to make any particular concessions or take any particular position, but it is a good idea for both parties to make some concessions, in part so that they can demonstrate if there's any challenge to their good faith negotiation. They can say, well, you know, I started the negotiation saying we would only agree to a 5-cent raise, and I've increased it to a 7-cent raise, and so you can see I have moved. And so when you are developing your negotiation position, it's probably a good idea to start where you currently are and to look for opportunities that you could have to provide a more generous benefit to workers. And it might be a combination of things. You might, you know, increase the hourly rate, but also increase the healthcare insurance premium, or maybe decrease the number of sick pay hours that are available to the employee. And so with one hand you give, the other hand you might be taking away, unfortunately. But that's a good strategy to figure that out, because the NLRB can decide that, well, even though that particular employer or union has gone through the motions, because they haven't made any changes in their position, maybe they really haven't been bargaining in good faith. It is not unusual for there not to be an agreement to be reached, that the collective bargaining negotiations has not resulted in an actual collective bargaining agreement. The fact that there is no agreement by no means proves that there has been a lack of good faith in the negotiations. It's actually a fairly common thing to have happen, especially during the first contract round. Again, the labor law requires only the parties negotiate in good faith about appropriate matters. We'll talk about what those matters are in a few minutes. It does not require that one party adopt the position of another, or that agree to the position that another person has advanced. So there are kind of two categories when we talk about appropriate matters. Really what we're focusing on is mandatory topics. There are certain things that are mandatory topic: wage, benefits, working conditions. Those types of things are mandatory topics. The union can't say, oh, we're not going to talk about that. The employer can't say, oh, no, that's off the table. Those things have to be negotiated, and if either party says, no, we're not going to talk about it, then that qualifies as failing to bargain in good faith. Then there are topics that are called permissive topics, topics that are not required. The parties can negotiate about that, but either side can say, we're not doing that. And that is not an example of bargaining in bad faith because it's not a required topic. So it's permitted, but not required. So let's look at some examples. So mandatory subjects of bargaining are wages, hours, and other conditions of employment which by law must be negotiated between labor and management. So examples would be obviously wage rates, but it could be healthcare benefits, retirement benefits, vacation and sick pay, holiday pay, things along those lines would be mandatory subjects of bargaining. Permissive subjects are those non-mandatory subjects. What would be an example of a permissive subject of bargaining? It could be how let's see, how a career path for people to enter into supervisory positions. That could be a permissive subject of bargaining. The employer would not be required to talk about that, but could if the employer were interested in doing that. Okay, let's talk about closed shops, and we're going to contrast this with the union shop. So what is a closed shop? It's a business in which the employer hires only already existing union members. You can see in a closed shop situation that the union controls who the employer can hire, because if the union refuses to permit Bob to join the union, then it's impossible for Bob to get a job within the bargaining unit. Closed shops are illegal, and requesting that the parties negotiate about a closed shop is an example of bargaining in bad faith. So closed shops are not a mandatory subject. They're not even a permissive subject. They are prohibited subjects of negotiation. But sometimes people get closed shops confused with union shops. In non-right-to-work state, union shops are perfectly legal and are very, very common. The difference is that in a closed shop, the person has to already be a member of the union before his first day on the job. In a union shop, they can already be a member of the union. That's not a problem, but they don't have to be. And the union has to let the person that the employer has hired join the union. The union can't say no. So in a closed shop, the union really controls who the manager can hire. But in a union shop, the employer is picking who it's going to hire, and the union is only allowing that person that the management has selected to, in fact, become a member of the union. So there's a big difference, but it all turns on when the person becomes a union member. A management security clause, this is when the parties agree that management has a right to run the business and make appropriate business decisions as long as all applicable laws and agreements are complied with. This is a very common clause in a contract. The idea is that the business has to be run. I mean, that's in everyone's interest for the business to be profitable, because if it's not profitable, there won't be jobs for anybody. And so a management security clause basically says the managers are going to manage the business. The employees are going to do what they are directed to do by the management. Sometimes there is negotiations at a set point during the length of the term of the contract because there may need to be adjustments, or perhaps certain terms haven't been established. Perhaps the amount of increase, for example, that the employees will receive. And so you set up the contract and then you say, and we'll talk more at this other date. Now, even if you don't have provided in your contract that there will be midterm negotiations, you always can reopen the terms because there can be changes in condition. Maybe at the time of the initial negotiation, the employer was very successful, was making lots of profit, and so the package that it negotiated was very advantageous for the employees. But now the economy has turned and layoffs are necessary. Well, the employees may want to renegotiate because it's better to have a job at a lower rate than no job at all, and so there can be a back and forth at that point as well. Let's consider a couple of scenarios. Mary has been involved with negotiations with the union representing her employees for over 7 months. An agreement has not been reached on any issue, although Mary has made concessions from her original position. Again, this is smart for Mary to have done this because it points to her good faith. She is unwilling to make further concessions. If no agreement is reached within a reasonable amount of time, Mary will not be liable for having committed an unfair labor practice because the law does not require that an agreement be reached. Only the parties bargain in good faith. Let's consider this other scenario. The Steelworkers Local Union represents the employees at Crocodile Tile Company. The union wishes to negotiate a collective bargaining agreement over wages, hours, and working conditions. So these are all mandatory topics of negotiation. But Crocodile Tile refuses to even speak to officials of the union. Under these circumstances, Crocodile Tile clearly is guilty of the unfair labor practice of refusing to bargain over mandatory subjects of bargaining. Here we have some key terms. Some of these we've already talked about. We talked about the right to work law that permits employees to choose not to become a union even though they continue to work in the bargaining unit. And again, about half the states have this rule. Usually states in the South do have that rule, and Texas is one of them. Then we talked about a union shop. Again, this is different than closed shop. Union and management agree that the employees must join the union within some period of time, typically about 30 days, after hire, and these are lawful in non-right-to-work states. Different, very different from the closed shop. Union shop clause, provision in a collective bargaining agreement allowing a union shop. So this is something that is only lawful in non-right-to-work states. And it's not automatic. I mean, there has to be a negotiation between the management and the union. So even in a non-right-to-work state, it doesn't follow that every single contract is going to have a union shop clause in it. I mean, the vast majority do because, of course, the union is very focused on it, and the employer honestly doesn't care very much. Okay, let's consider agency shop clauses. These are prohibited under Texas law. It requires non-union members to pay union dues without having to be subject to the union rules. So this is kind of like it's kind of quasi membership in the union, but that is prohibited in Texas. It cannot men and women who work in the bargaining unit do not have to pay union dues, and they don't have to affiliate with the union in order to keep their jobs. And that's, of course, leads to that free rider issue that we talked about before. Free riders are the bargaining unit employees who do not pay union dues, but whom the union is obligated to represent. Again, this is only an issue in right-to-work states. Okay, so let's assume that the parties have gotten together, they have negotiated and arrived at a collective bargaining agreement. This agreement is obviously going to have provisions that put certain responsibilities on the employer, certain responsibilities upon the union, and by extension upon the workers. Invariably, it's going to happen that an employee feels like some term of the contract has not been complied with respect to him or her. This is a very common type of matter. And when those issues arise, we say that the employee has a grievance or the employee is grieving that particular issue. And what he or she will likely do is go to the shop steward and say, hey, I've got a grievance. And the shop steward will accept the grievance, will write it up, and will negotiate or talk with the management about this issue. If the management may look at it and go, oh yeah, you're right, we screwed up there. We awarded overtime not based upon seniority as is required by the contract, and Bob was denied overtime that he should have received because he had more seniority than Sarah. And so we're going to have to pay Bob what he would have otherwise earned, for example. If, though, it can't be resolved through this back and forth discussion, then there will be, steps to the grievance process, and you actually look at the contract to figure out what the steps are. But eventually, it will get to an arbitrator who will consider the dispute and will decide whether the contract was complied with or not. When the terms of the collective bargaining agreement don't sufficiently answer a question, either there's silence on the issue or it's ambiguous language, the arbitrator can look at past practices to see how have these two parties handled this issue in the past. This idea is a really foundational idea in contract law generally. So this is treating labor contracts just like we would any other contract under the law. So let's consider a scenario here. Garter Snake Industries approaches union officials about scheduling midterm negotiations in accordance with the collective bargaining agreement. The union refuses to meet with management, claiming that there is nothing to negotiate. The union's refusal to bargain with Garter State is illegal because refusing to bargain is an unfair labor practice. Okay, so that gives an example of how the union also has a duty to bargain in good faith. Don't want to focus too much on this case. What this case has to talks about the fact that in the collective bargaining agreement that this particular company, Chevron, had with the union, it had a provision in it that said that Chevron had the right to inspect or to search cars of employees that are in the parking lot. Well, Mr. Strike said, well, no, I don't agree to that. I don't want my employer to be able to search my car if I have it locked up. It's none of the business of the employer, even if I have it on the employer's work site. Well, the court said, well, Mr. Stikes, you didn't have a reasonable expectation of privacy because you had access to this collective bargaining agreement, which basically made it clear that your car could be searched if you chose to bring it onto the Chevron's parking lot. There was no reasonable expectation of privacy under these facts. So you can see in this case, the collective bargaining agreement took away rights that Mr. Stikes probably otherwise would have had. If there hadn't been a collective bargaining agreement, probably Mr. Stikes would have had a good argument that he did have a reasonable expectation of privacy in his locked car, especially for things that were not visible from the exterior of the car. So this is an example about how people can be affected. And keep in mind, let's say that Mr. Stikes was working in a facility that was a right-to-work state and he had not chosen to join the union. Even so, he is going to be bound by the terms of that collective bargaining agreement. And so he would have lost his reasonable expectation of privacy, even though he's in a right-to-work state and he's opted not to join the union. Okay, so let's talk about the situation of strikes. What happens when the collective bargaining fails? Because one situation that will result in a strike oftentimes is when the collective bargaining breaks down. There doesn't seem to be any possibility of reaching a contract, and so very possibly the union decides to strike. There are other times where they strike as well, but that's one scenario that is a fairly common one. When the negotiations break down, we say that we've reached an impasse. The parties are deadlocked. It doesn't appear that there's any utility in continuing to negotiate at this time. And so one thing that can happen is the union can decide to strike. Another thing that can happen is that the employer can decide to lock out the workers. But let's assume that the employer has decided not to lock out workers at this time, and the employer wants to just continue as is, keeping its business doors open and allowing the workers to work there. Well, what is the current terms and conditions of employment? Well, when you really have reached an impasse, the employer can implement its last offer. So let's say that prior to the union campaign, workers, let's say everybody in this bargaining unit does the same job. Workers were earning $10 an hour. Throughout the negotiations, the union wanted the pay to go up to $13 an hour. The employer offered to increase it to $11 an hour. They negotiate, and there's just no movement. There doesn't seem to be any possibility of persuading the union to come down off 13 or to persuading the company to come up on 11. They reach an impasse, and so now the employer says, well, okay, our last best offer was $11, so that's what we're changing the employee's wages to. And so that is the way that this could happen in terms of establishing a new pay rate. Whatever the reason, assuming it's not an unlawful reason why the employees choose to strike, the employer cannot fire the employees because that's one of the protected rights that employees have, to strike. There are some types of strikes, though, that can be unlawful, and because they're not protected activities, they can result in termination. One of them is a sit-down strike. This is when the employees oftentimes literally sit down in the workstation and stop anyone else from working there, and yet they aren't working there either. So what they're doing is they're occupying the facility and making it impossible for anyone to work at that workstation or accomplish tasks. So it's kind of like a strike in that they aren't working, but it's worse for the employer than a strike because they are stopping anyone else from working there. And that is unlawful. It's not a protected activity. If you've ever seen the movie Norma Ray, what happened there was a sit-down strike when they refused to leave. Another type of strike, which is also not protected, is a wildcat strike. This is a strike that is not sanctioned by the union. The employees themselves decide, we're not taking it anymore. And usually it's not all of the employees, because after all, if it were all the employees, then the union would vote to strike. A majority of the folks would be voting to strike. But maybe this is a smaller contingent who feel strongly about a particular issue. Well, again, the whole purpose of the union activity is for the group of employees to be united. Now, obviously, no one's so naive as to think that any group of people are always going to agree about everything, but it's majority rules. And so you consider, well, most of the folks voted against a strike, so therefore you don't have the option of striking. I mean, you can resign your job, you can go about your life and do something else. That's fine, that's your right, but you don't have the right to strike. Another category of strikes, or another category of strikes that are unlawful, is when federal employees strike. Most of y'all are too young to remember this, but when President Reagan was president, the air traffic controllers struck, and President Reagan fired them all because they did not have that legal right to strike. And in fact, generally speaking, federal unions are not very much like private sector unions, because federal employees through their unions cannot bargain over wages, hours, or benefits. So it's a very different creature than what we see in the private sector. Now, postal workers do have some rights in this area, that they have more rights than most federal employees do in the union situation. Let's talk about picketing. Picketing is when union members carry signs in front of the business. They're striking, or they don't have to be striking, although commonly picketing and striking go together, but it doesn't have to be. In fact, a person can just be not on the clock for that particular time, and they will picket, and then when it comes time for them to go to work, then they might go on to work. So the purpose of the picket could be to tell folks about maybe customers or management, or that these workers are unhappy, that they feel that there's an unfair labor practice, or that they're striking. They're not going to be working under those circumstances. So these are some important vocabulary terms for you to become familiar with. So there are two categories of lawful strikes. The first is an economic strike, and this is a common thing that happens. This is when the collective bargaining agreement breaks down, and or actually isn't entered into at all, and the union folks just don't think they're getting a fair deal. They feel like they should receive more. They ought to receive higher wages. They ought to receive more benefits. They ought to be given more hours. I mean, whatever the issue is, they want to improve their lot. A perfectly legitimate thing for them to want to do. When an economic striker strikes, though, they are not able to, or they can be temporarily replaced or they can be permanently replaced. What happens if they are permanently replaced during the time that they're striking, then even if they agree to come back to work, there isn't a spot for them, and the employer can keep that replacement worker for as long as that replacement worker chooses to work. Now, if the replacement worker leaves the next day, then the employer has to reinstate the economic striker. But that replacement worker might stay there for 30 years. And so that poor economic striker is never going to, or at least not for 30 years, going to be able to return to that particular slot. So the rights of reinstatement for economic strikers are not especially awesome. Let's consider the ULP striker. This is a striker who is protesting through his strike some unfair labor practice that was committed by the employer. In this situation, ULP strikers can be temporarily replaced just like the economic strikers can be. But as soon as the ULP strikers make an unconditional request to return to work, the employer has to fire those or assign them to some other position, those replacement workers. So you can see that a ULP striker has much more job security than the economic striker. As a result, unions prefer, obviously, to characterize their strikes as ULP strikes so that it gives their workers more security. So this is an important distinction to make between the economic striker and the ULP striker. Let's consider this scenario. The employees of Poodle Manufacturing are represented by a union. All the mechanics who repair the company's equipment work day shifts, which means that if an equipment breaks down in one of the other shifts, Poodle has to pay overtime or suffer lost production. Poodle proposes to the union the mechanics be assigned rotating shifts to solve the problem, but the union refuses. Poodle then unilaterally changes the shift assignments in accordance with its proposal. The union, sensing malpractice, goes on strike, and Poodle replaces the striking mechanics. So what it's all going to turn on is whether this was a ULP or not. Was this an unfair labor practice for Poodle to unilaterally change the shift assignments? And it's going to turn on whether there was really an impasse or not. Did Poodle jump the gun before a true impasse had existed? We don't have enough facts in our scenario to know whether we really were at an impasse or not. So let's see what the NLRB says. The NLRB finds that Poodle had indeed committed malpractice. In other words, a true impasse had not happened. So this was a ULP strike. If the striking mechanics make an unconditional offer to return to work, Poodle must reinstate the mechanics because they are ULP strikers. So Poodle has to fire all of the temporary replacement workers that it had put into a position in the interim during the course of the strike. So let's talk about lockouts. Lockouts are kind of the equivalent of a strike, but from the employer's perspective. The employer doesn't allow the unionized workers to come to work. They literally locks the door, and so the employees want to work. They show up for work, and yet they're not permitted to go in. This is a perfectly valid action for management to take. Under these circumstances, obviously, management can't hire replacement workers, although it can use management, both under the striking scenario and the lockout scenario, to do the tasks that are traditionally or usually done by the bargaining unit employees. So while a lockout is perfectly lawful, it cannot be used as a way to avoid bargaining. Let's go through an example so you can see what we mean here. Okay, so Blowfish Industries reduced employees' benefits as a means to cut costs. The union wanted to enter into a collective bargaining agreement, but Blowfish rejected its demands and refused to bargain and listen to the union's proposals. So we seem to have a very clear ULP here. The following day, Blowfish locked the employees out. The lockout was a violation of the NLRA because an employer cannot engage in a lockout as a means to avoid bargaining. You can have a clause in your contract that says, hey, the union's not going to strike and the employer's not going to lock out the union members. That can be a way to kind of get a labor peace, at least during the span of the time of the contract. Pretty common provision to see in a collective bargaining agreement. So let's talk about the right that the employees have to picket. It's not a limitless right. So for example, even though we have the right to picket, we don't have the right to picket in such numbers that there's just no ability for people to actually enter the workplace, those folks who choose to cross the picket line. You may have heard the term for these folks. Some people call them, this is not a polite word, uh, but instead of saying picket crossers, they might call them scabs. But again, that's not a nice word under these contexts, so you don't want to use that term in everyday conversation, but you'll hear it in those circumstances. The picketers can't threaten force or violence on the picket line. They obviously can't engage in force or violence on the picket line. Obviously, that would be a crime, but it would also be a ULP. And then a union cannot fire union members or fine them for crossing the picket line. Now, union members are oftentimes loath to cross picket lines. They are not going to be beloved by those folks who happen to be walking the picket line. There can be lots, friendships and long-term relationships can be dealt a pretty bad blow in these situations. I mean, emotions run very, very high. But even though friendships might be destroyed and the government can't really regulate friendships, the government can say that those members who cross the picket line cannot be fined or expelled from the union. So at this point, we're going to end this lecture, and we will have another lecture where we'll talk about unfair labor practices. Actually, let's go on and cover unfair labor practices, just to kind of finish up this topic here. So we're going to, obviously, both the union and the employer can engage in, I mean, they're not supposed to, but it's possible, theoretically, for them to engage in unfair labor practices simply because the statutes make certain behaviors unlawful for the employer to do and make certain behaviors unlawful for the union to do. So let's look at from the employer side. So employers can't refuse to bargain in good faith. They have to bargain in good faith. They cannot engage in activities that would tend to indicate an intention to control or influence the union, and they can't interfere in union affairs. For example, an employer can't try to help a particular union candidate win a union office. If you think about it, if that were permitted, then the candidate could say, hey, you know what, if you give me a kickback, you give me some money, well, I'll be sure to not negotiate very hard against y'all. So you can see how that would really undermine the collective bargaining process and the whole idea of union democracy. Let's talk for a second about electromation. Electromation is a big case. It's a controversial case. Electromation had to do with employee safety groups. These are very, very common in industrial settings. Obviously, one of the things that happens in industrial settings is that there is the potential for people to get injured at work, even killed at work. And so there's a lot of logic to having the folks who are the experts in how the job should be done develop safety procedures to reduce the likelihood of those risks. It's good from a logic standpoint, but it's also good from a psychological perspective. It's people who know that, hey, the people who came up with this rule know the job, have been in the position, they're like me. And so it's more likely that the people who have to follow the new safety rule are going to feel that they have had a voice, that they are going to feel some buy-in with this. They're more likely, honestly, to follow the rule under those circumstances. So it's a good idea from lots of different perspectives. But there's a problem with it. And the problem has to do with that idea of a company-controlled union. Because now the workers are discussing, because typically these committees are mixed. There'll be some people in management on the committee and some people that are hourly paid workers, who the type of people that could be in the bargaining unit if the unit were organized. And again, these happen in non-organized or non-unionized facilities. So there's a give and take in these committees about working conditions. The unionized folks might say, well, we need, one of the reasons we're having so many accidents is we're not getting enough breaks. We need some time away to clear our head, to kind of refresh ourselves. And so if you give us an extra break, we'll have fewer accidents. And the management might say, oh, we can't afford another break. That's not going to work for us. And so you can see how it starts sounding like it's a negotiation about terms and conditions of employment, except this entity that's engaging in it is a union, employer-controlled organization. The employer selects who the employees are. The employer decides what the topics are that this particular committee can address. And the idea of an employer-controlled union is absolutely prohibited under the NLRA. So the idea is that some of these safety committees can actually be violations of labor law. Now, most of the people who are on these safety committees would say, oh, this isn't a union, this is a safety committee. It doesn't quack like a duck, it doesn't waddle like a duck, it just doesn't seem like that's what it is at all. But in defense of the position that the NLRB has taken, one of the reasons why unions have adopted these types of safety programs is in the hopes to, as part of an anti-union or union avoidance approach. Again, trying to get employees to feel like they have a voice, that they can affect the working conditions. And so there is just a bit of grain of truth to this idea. And so electromation is an opinion that you ought to be familiar with as you design, if you choose to use these types of programs where you have safety committees or other types of committees. It might be an MLK parade float committee that is mixed supervisors and managers, or it could be a barbecue contest that management and employees are going to design together, organize together. So there can be lots of different types of committees that could possibly run afoul of electromation. Another thing that employers can't do is discriminate against employees who assist or join unions. Now, when I use the word discriminate here, I'm not talking about racial discrimination or gender discrimination. Under the NLRA, discrimination is focusing upon the protected category of being a union supporter. So the discrimination isn't about one immutable characteristic like national origin or religion or race or age or disability. It's about whether this person supports the union. So keep in mind discrimination, what it means in this context. The bottom line is that an employer can't terminate employees who support the union obviously they can terminate employees who support the union if they've got a valid reason. But if the real reason that they're wanting to dismiss the person is because the employee supports the union, that is unlawful. And in fact, no negative action can be taken. No suspensions, no demotions, no drop in pay, no denial of promotions can happen for the reason that this person is supporting the union. So let's consider a couple of scenarios. The Lemming Institute has a policy that prohibits any employer, whether or not a representative of the union, from distributing any union literature or notice. It also stated that employees can be dismissed for supporting or joining a union and that they should address any issues using the formal complaint process. Obviously, both of these policies are unlawful. They both can be considered an unfair labor practice. The Lemming Institute has committed the unfair labor practice of coercing employees in the exercise of their rights under the NLRA. But by threatening discipline, it's affecting the behaviors of the employees in a way that is unlawful. Let's consider Manatee Manufacturing. Manatee Manufacturing was targeted by a union campaign. The union organizers contacted Bob, an assembly line employee, so someone who might be in the bargaining unit, to assist them in the process of unionization. When management at Manatee came to know that Bob was working with the union organizers, they fired Bob, so clearly a discriminatory action. They also instituted a new rule requiring employees to leave the company property within 15 minutes after the end of their shift unless speaking with a member of management. In other words, they're trying to stop there being conversations about union, about, maybe by pro-union folks talking to people who are still hanging around about maybe you want to join the union. Under these circumstances, Manatee has committed an unfair labor practice because it discriminated against Bob for assisting the union. Also, the second policy, the 15-minute policy, is probably also going to be a violation of or an unfair labor practice, especially if um, uh, the NLRB finds that Manatee developed this policy in the hopes of, in the midst of a union campaign, in the hopes of discouraging union interest. This is a neat slide that kind of goes through how the NLRB is going to look to see if there is a ULP. First question they're going to ask is, did the employee who was terminated or whatever, did that employee engage in protected activity? Were they doing things to advance the union? For example, distributing leaflets talking about how good unionization is going to be, distributing authorization cards. So that's the first thing. Usually this one's quite easy to prove. The next thing is the employer was aware of the protected activity. In many cases, it's very clear who's doing it. Everybody's talking about it. And the employee oftentimes makes a point of doing it in front of the employer so the employer knows exactly what's going on. The employer has demonstrated hostility toward the protected activity. This one can be a little bit more difficult to prove. Because it's not enough that the employer opposes the union, but the employer has to indicate, oh, I don't like that you're distributing those handouts or whatever. So there has to be some evidence of this, but it doesn't have to be direct evidence. It can be physical demeanor of people, things that are said or done that may not be directly saying, I don't think you ought to be doing X or Y or Z. And then finally, there has to be a causal link between this hostility and the decision to deny the employment opportunity or to terminate. You can see here, this is the same prima facie case that we saw under Title VII, right? Instead of protected activity, it was protected characteristic like race or national origin or gender. He engaged in protected activity. I guess here this would fit into the idea of he was qualified for the job. And then finally that he was replaced by somebody who he was qualified for the job, but something negative happened to him. So there was some negative adverse employment action. And then finally there was a third element, which usually is going to be, in Title VII cases, is going to be a person who isn't a member of the same protected class was hired. But you can see this tracks pretty darn closely with that same analysis that we saw under Title VII. We already talked about employee participation programs. Those are the electromation type things, which include employees and decisions previously reserved for management may be deemed labor organizations, but because they're likely dominated by employers, because the employers picks who's on it, controls the agenda, these may well violate the NLRA under the electromation decision. Okay, so we've talked about what employers cannot do under labor law. Let's talk about what unions cannot do. So a union cannot restrain or coerce employees in the exercise of their rights under the Act. So obviously, just like the employer can't fire people because they support the union can't adversely treat employees who support the company. Let's say the union is voted in, they can't retaliate against those people who voted against it. The union cannot cause an employer to discriminate against an employee for the purpose of encouraging or discouraging membership in a labor organization. So let's say that Bob is the person who, under the terms of the collective bargaining agreement, should be eligible for that promotion. But the union doesn't like Bob, maybe because Bob supported the company and opposed the union during the campaign. The union can't say to the company, hey, we don't want you to promote Bob. I know that's what the terms of the collective bargaining agreement would ordinarily require, but we want you to promote Sally. Sally's a good union person. That would be an unfair labor practice. Again, there's a refusal to bargain in good faith. Broaden labor disputes to include neutral employers. This is that secondary boycott. Let's talk about what a secondary boycott is. First of all, it's illegal. That's probably the most important thing to know about it. This is when a union tries to pressure management that that they have already organized. So this is an organized unit to do business to apply pressure on management created by getting others who do business with management to cease. So this is I think there's a word here missing. So basically, a union is has organized Company A, and everything is fine with that relationship. But Company A uses the services of Company B, and Company B is not unionized. So the union says to Company A, well, listen, we don't have a gripe with you, but we don't want you to do business with B because it's not unionized. So we're going to picket you and continue to picket you until you stop doing business with B. That's what a secondary boycott is, and that is unlawful under the law. Another thing unions cannot do is charge excessive initiation fees or dues. I guess we really haven't talked about dues too much. Dues can vary. Sometimes it's a flat fee, but a very common approach is to have it be the hourly rate of the employees. And that's kind of a good idea because it aligns the employee's interest in maximizing his income with the union's interest. And so when there's contract negotiation, the union has an interest in focusing upon wage increases, and the employees have an interest in focusing on wage increases. The union's interested in it because whenever the employees get a wage increase, if the union dues are set up to be a number of hours of pay, then they're going to automatically get an increase. Of course, that's not the way it is for every single contract. There are, union arrangements. Sometimes there's a flat hourly fee. A flat fee that the union member has to pay every month. It's usually on a monthly basis. One disadvantage to having the 2 or 3 hours a month be the fee structure is that oftentimes it's the same whether the worker is part-time or full-time. So in this situation, I did a calculation based upon each month having 4 1/4 weeks and each week having 40 hours of labor. So that works out to be 2 over 180 hours. And so that's about 1%, a little bit more than 1% if we're using that 2 hours a month number, which is pretty common. But let's say instead you only work 10 hours a week. So then you're only going to have 2 out of 4.25 times x, times 10. So that would be 2 over 42.5. And so we're looking at more like 5% of the pay. You can see then how if you're full-time, you think it's a pretty good deal. If you're part-time, you don't think it's such a good deal. And so it's possible for firms or unions to have some kind of variation. For example, maybe it's 3 hours if you're full-time, 2 hours if you're part-time, or something along those lines. In addition to the dues, there's also going to be typically some fee to join. And they can't be excessive, but it's kind of a membership fee. And there can also be penalties and fines if the employee violates certain rules that the union has, and those can't be excessive either. Another thing that is an unfair labor practice for the union to do is to cause an employer to pay for work not performed. This is feather bedding. So, for example, you can't, let's say, once upon a time in your facility, there were people whose job was to keep the bring coal up to heat the boilers to warm the um, factory so that the workers wouldn't get too cold. But 10 years ago, the business bought a different kind of heating system that uses gas. And so there's no longer any coal to feed the boiler. And so there's no need for coal workers to shovel the coal and put it in the boiler. So what should happen is that those jobs would go away. I mean, the workers who have been doing that kind of work might be given other positions, but there's no need to have coal shovelers anymore. But in a feather bedding type of operation, what you do is you say, well, we've always had 4 coal shovelers, so we'll still have them. There's no coal for them to shovel, but they'll just stand there for 8 hours a day. That would be an example of feather bedding. So it is an unfair labor practice for unions to cause an employer to pay for services or goods that are not provided. Unions also cannot picket for more than 30 days for the purposes of obtaining union recognition. We talked before how the usual route for union recognition is through that election process. But the employer can recognize the union if the union shows the employer 50% plus one union authorization cards from the people who are potentially members of that bargaining unit. Well, one way to hopefully from the union's perspective to persuade the employer to agree for this voluntary recognition would be to picket, because that might make the employer feel like, oh wow, we don't want this picketing to go on, it's driving our customers away, and so we're going to go ahead and agree to the recognition so the pickets go away. But it is an unfair labor practice for the union to picket for more than 30 days. After the 30th day, they have to stop the picketing if it's for the purposes of obtaining union recognition without a vote. My guess is the 30-day requirement is due to the fact that once the election petition is received, typically there's going to be a vote within 30 days. So if the union is simply trying to speed up the process of getting recognition, then there's really no need to picket when you could just have the whole vote in 30 days. Let's consider this scenario. Red Weasel bids on a job to install a heating system for a new office building. Aardvark Construction is a general contractor, so this is the main business, Aardvark. And Aardvark is seeking proposals from probably a variety of subcontractors. One of them is Red Weasel. So Aardvark is a general contractor responsible for hiring subcontractors such as Red Weasel. Aardvark construction employees are represented by a union, but Red Weasel is a non-union employer. The union has been trying to organize Red Weasel for a while, and Red Weasel has been unwilling to agree to recognition. The union sends emails and letters to the workers at Aardvark asking them not to report to work until Aardvark Construction rejects Red Weasel's bid and instead selects a union subcontractor. In this case, the union has engaged in the unlawful activity of secondary boycott, and that is an unfair labor practice. So this is an example of this term that we saw over here. Here we go. Okay, so this is an important case. It's a rather old case, but still an important one, which is NLRB versus Exchange Parts Company. Does the NLRA, that statute, prohibit an employer from offering benefits to employees in order to sway the outcome of a union representational election? And the answer is yes. It's obvious you can't threaten, but you also can't promise. The TIPS acronym says the employer can't threaten, can't interrogate, can't promise, and can't surveil. And so promises are also saying, hey, we'll increase vacation pay if you don't vote the union in, or we'll increase overtime benefits if you don't vote the union in. We've heard you. We want to respond to what your concerns are. There's no need to get the union involved. We've got your message loud and clear. We're going to fix things. That is an unlawful thing to say. So now, or in our next lecture, we're going to talk about Taft-Hartley. We're going to talk about how it amended the NLRA, and we'll talk about the specifics of that in our final lecture. I thank you for your attention. If you have any questions about the material that we've talked about today, please feel free to send me an email. My email is cgroover@collin.edu, or better yet, come by my office hours. I would be delighted to talk to you in more detail about this material. I thank you for your attention, and I hope you have a wonderful day.